I'm Judd Campbell. I'm a constitutional law professor at the University of Richmond, and I'm going to unpack the Supreme Court's recent decision in Mahanoy Area School District versus BL. This was a case that hit the news recently about a high school JV cheerleader who was kicked off of the squad because she posted some pictures to Snapchat that were crude and that included captions where she was dropping the F-bomb. And because she was kicked off, for having posted these pictures, she brought a First Amendment claim saying that it was a violation of her speech rights. And the thing to understand about the case as background is that the Supreme Court has not simply adopted one set of rules to govern speech claims, but instead has a bunch of different sets or buckets of rules that apply to different contexts depending on what role the government is performing. So there's a normal set of First Amendment doctrines that apply if the government is just restricting private speech. But separate rules govern the efforts of the government to try to exclude speakers from government property. That's called public forum doctrine. Or that try to prevent public employees from speaking in certain ways that are in some way harmful to their public duties. That's public employee speech doctrine. And then importantly for this case, the court has embraced a set or bucket of rules that govern school administrators' effort to limit the speech of students. And the lower court in this case basically said that bucket of speech doctrines that allow school administrators to go further in restricting student speech than the government would normally be able to go in restricting private speech. That bucket of speech doctrine stops at the schoolhouse gate. And this is a famous metaphor mentioned in the Tinker case, a case involving Vietnam War protests in public schools in Des Moines. And so the lower court had taken a very rigid approach saying on school property, when you're in school, the government can go pretty far in limiting student speech, but off of school property, normal speech doctrines apply. And the Supreme Court decided in this case not to take that approach. Instead, what it said is that the school administrators can sometimes go further in limiting student speech outside of school than the government would normally be able to limit private speech. But it is more limited in that context than it would be were the speech to happen on school property with school resources and so on. And so the court here is discouraging public school administrators from restricting student speech outside of school, but also recognizing that there might be some situations in which the speech is so disruptive to school activities or is harassing of other students. And in those situations, there might be, the court says, warrant for the government as public school administrator to come in and restrict speech in ways that the government simply as regulator of private behavior would not be able to.